to show you how popular our panelists are, that we have a panelist that was finishing up someplace else and is MIA, but is the third speaker. So, so that just shows you how popular these our panelists are here. So, but ready for the second panel of our morning here. So, so Betsy, turn things over to you and your group.
Thank you. Hi, everyone. I'm Betsy Popken. I'm the Executive Director of the Human Rights Center at UC Berkeley Law. And I'm joined here today by two colleagues, one and a third who will be joining us shortly. First is Jay Aronson, who is the Professor of Science, Technology, and Society and founder and director of the Center for Human Rights Science at Carnegie Mellon University. And to my right is Jose Torero, Professor and Head of Department, Civil, Environmental, and Geomatic Engineering at University College of London. And we'll be joined later in this panel session by Julie Owono, who's Executive Director of Internet Sans Frontières and inaugural member of the Oversight Board at Meta. Today we're going to be discussing seeking justice and remediating harms. And you'll see from this panel discussion that we all come at this issue from very differing perspectives. And so you'll learn a lot from kind of our individual experiences on kind of the remediation of human rights harms. So I'm going to be talking to you today about oh, and Julie is here. Welcome, Julie. I'm going to be speaking with you today about a human rights assessment of large language models like ChatGPT that I am leading at UC Berkeley's Human Rights Center. And I want to start off by asking people questions, and let's do this both kind of in the audience as well as online. Who here uses ChatGPT? Okay. And how many of you use it in your work? Okay. Keep your hand up if you use it in your work. Right here, can you tell me what work you do and how you use it in your work?
I'm completing a PhD in biomedical engineering, and I find it very useful when remembering syntax for my MATLAB scripts.
Okay, thank you.
Or also to tell it to provide me a reverse outline of something I've written to make sure I'm communicating what I thought that I was.
Okay, thanks. Can you raise your hand again if you use it in your work? Over here.
Hi, I just actually finished up using it in my dissertation to clean up YouTube transcripts of 20 hours of publicly available National Science Foundation Commission meetings. And so that really simplified the workload as a sole researcher with a dissertation budget of 0. To be able to translate these transcripts into easily readable and analyzable formats.
Thank you. And one more show of hands who uses it in their work. Over here.
A lot of times I'll use it, like you can throw in a lot of your work and be like, what are the main ideas you got out of it? And if it's not the main ideas I wanted it to be, I can either go back and refresh. A lot of times to check my language if I don't want it to sound academic. Depending on the audience, I'm like, this is my audience for my presentations. And then also just when I'm building out some, if I'm teaching a class or something and there's certain topics that I want to make sure I'm covering, I just sometimes will just use it in different varying ways like that.
Yeah, I've used it in a few different contexts myself in work. One is if I'm kind of researching a new space, a space that's new for me, I'll just enter, for instance, what are the environmental impacts of AI data centers? And it'll just pop up. And then I use that to connect them to kind of the human rights harms and know kind of a starting point to research further. I've also used them after a big event in this country that happened fairly recently. We drafted a statement from the Human Rights Center, and it was the day after this big event, and I was in a bit of a brain fog. So I drafted the statement, and then I just put it into ChatGPT, and I was like, make this sound better. And it provided kind of different ideas to kind of spice it up. So that's just a couple of examples, but I know, and we've talked about at the Human Rights Center, the way different people at the center use it, and based on their job responsibility, it varies quite significantly. So I am leading a team at the Human Rights Center conducting a human rights assessment of the use of large language models like ChatGPT in 3 professional fields. We're looking at the legal profession, education, and journalism. But before I get into the specifics, I wanted to show a little bit of background on what remediation is, and we'll just do this very briefly. Yesterday, you heard about the UN Guiding Principles on Business and Human Rights, and this was kind of the founding document in 2011 that placed responsibilities on corporations to respect human rights. And it requires a human rights policy, a due diligence process, and then remediation. And what that means is kind of making those people who have been harmed by your products or services or activities as whole as possible. And this is just one of the sections in the UN Guiding Principles on Business and Human Rights that discusses it. And it mentions processes to enable the remediation of any adverse human rights impacts they cause or to which they contribute. So our human rights assessment of large language models took kind of 4 parts. And I should mention, we're almost completely done with the human rights assessment, but we still have to, we're kind of in the drafting phase right now. And we expect it to be released in Q1 of 2025. The first step we took was a literature review. So we were looking at how do the use of LLMs impact human rights, or what rights do they put at risk? And we looked globally, and both at kind of what experts have said as well as what have users said. And then we looked into the specific professions. There actually has been a bit written about how LLMs are used in the legal profession, or how they're used by journalists, or how they're used by educators and those being educated. So we did a literature review to see what was already out there about the risks at play when people use LLMs like ChatGPT. Then we conducted global stakeholder interviews. And by stakeholders, we kind of identified 3 different stakeholder groups that 4, I guess, stakeholder groups that we interviewed. One was anyone with an expertise in natural language processing, machine learning, LLMs, LMMs, but we wanted to get a sense of those people who knew about these and knew about the real risks at play. And so we interviewed those, and looking at experts kind of across the globe, understanding that people have different perspective based on where they live and where they work. Our next set that we interviewed were people who were experts in LLMs and one of the specific professions. And we actually, it was a little hard to find that in some parts of the globe, but we found someone in we kind of divided the world into 6 different segments, and we found someone in each who was an expert in both kind of LLMs as well as each of the 3 professions. And then our last set of global stakeholder engagement we did was with practitioners. So we interviewed journalists, interviewed educators, interviewed legal professionals, and said, how do you use these in your work? And we found that the way people use them and their work varies so significantly based on where in the world they live and work. I would say here in North America and in Europe, tends to be a very conservative approach to using LLMs and very risk adverse. And in other parts of the world, they are breaking barriers with how they use it, which increases the opportunities manyfold, but it also increases the risks. And we'll talk about that a bit later. So that's kind of one of the reasons we wanted to do global stakeholder engagement, because we realized that the way that people use it is going to vary so significantly, and therefore the risks are going to vary quite significantly as well. Our last stakeholder group that we interviewed were the 4 companies who produce the 4 most used LLMs. So talking about ChatGPT, Gemini, Llama, and Claude. Our next step was an assessment of the human rights risk. So we took what we learned in the literature review, and we took our kind of what we learned in the interviews of stakeholders, and we identified what are the risks at play for each of the professions individually. What do we see as the biggest human rights risks? We also looked at opportunities. So, there are risks, but there are also opportunities. Particularly we found in the area of education, it can level the playing field. If there's access to everyone involved, it can play some role in leveling the playing field. And we use this and a methodology that you'll all be learning in the practice session later today to assess the severity, scope, and remediation of those impacts. So I'll be talking a bit more about those. The final step was to develop recommendations, and we wanted to, recognizing that there need to be multiple players at the table to make resolution and remediate some of these human rights risks, we wanted to provide recommendations to multiple groups. The first group was policymakers. We worked with a law firm to conduct a review of all of the regulations and guidance on AI worldwide, and those that specifically reference generative AI. And we pulled from kind of some of what we perceived to be kind of the best regulations. We also wanted to provide recommendations to industry groups. So the legal profession, journalism, education, there are industry groups surrounding all of these professions, and often they're regionally based. And then the third, which I'll be talking more about in a minute, is companies developing LLMs. We wanted to provide recommendations to them to better avoid risks in developing the products and rolling them out. So just to give you a few examples of risks we identified risks in each of the professions and then some cross-cutting risks as well. And so the cross-cutting ones are kind of the ones that we hear more about, which is right to privacy. People are concerned. You enter your information into ChatGPT. It utilizes that information to build upon its model and program. But we also, our goal was to identify risks specific to each of the individual fields. And I'll just outline one risk that we identified for each. These weren't necessarily the top risks we identified, but just ones where I can give you some stories. So journalism, we found in journalism that reporters in South Africa and India were using ChatGPT to write stories about weather and about market conditions and about sporting events. And so, we thought about, everyone knows that ChatGPT and other LLMs hallucinate, right? They don't always provide correct information. So, that would be a violation of the right to access to information, but there are also really significant potential downstream risks. So if you're reporting on weather, let's say you're reporting on a hurricane, and you report the wrong, ChatGPT causes you to report on the wrong location or coordinates of where the hurricane's going to be, that could lead to like loss of life, that could lead to injury to health, that could lead to a lot of other downstream risks. So that's kind of one in the journalism field. We identified one of a number of them. Law, we found that in interviewing folks in Latin America and South America, that judges were using ChatGPT to help them make judicial rulings. So a judge in Mexico asked ChatGPT whether to hold a hearing in the metaverse. Maybe you know about this. And ChatGPT said, yeah, sure, why not? But two that I thought were really interesting that happened in South America, two different countries in South America. One was a judge asked ChatGPT, how two parents should kind of split division of child support. They're two divorced parents split child support. And so it asked ChatGPT for an answer to that question, whether then making that determination his or herself. And then another one was a judge asked ChatGPT to what extent parents should be paying for the medical provisions for their child versus an insurance company. Like who should pay what percentage? Who should be responsible for what percentage? So anyway, it was just an awakening to the fact that use of LLMs in the legal profession, and that's not kind of getting to the area of if it's used in like criminal prosecutions, et cetera, but it really can violate the right to fair process and the right to a fair trial. Education, again, I mentioned earlier, we found a number of opportunities in the education sphere in terms of if people have, students have equal access to ChatGPT, it could provide kind of a leveling of the playing field for those students. But we also learned that, teachers in both the UAE and Singapore were using ChatGPT to assess student work product. So they would put the student work product in and say, give me feedback, give me a grade. And so that was just interesting. And also in talking to them, one of their biggest concerns was that students using ChatGPT, and this came from even professors and teachers of like K through 12, said that they were worried that students using ChatGPT was going to take away their ability to like think through things and make decisions on their own. So if you're writing a paper and you're a student and you say, please write a paper on the risks of large language models for me, rather than the student having to think themselves about like, okay, what is a large language model? What might the risks be in different contexts? They have ChatGPT putting it out for them, so they don't have to think about the issue. They don't have to research the issue. They don't have to think through how they're going to go through the writing process and develop it. They just have it right there in front of them. And so a lot of educators expressed a fear that this would change the way that students thought and impact kind of their education. And so freedom of thought was one human rights risk that we saw really at risk as a result. And then I'll just go over this briefly. I mentioned we provided recommendations to policymakers, industry groups, as well as companies developing large language models. And, in our interviews with the companies developing large language models, we learned about different things companies did before they rolled out their product, as well as things they continue to do while their product is in use. And so some of these are already at play at some companies, and others are are not at play at any companies. But just to give you a few examples of what we recommended is providing filters such as displaying text with a warning or not at all, consulting experts and users in different parts of the world, which is something that a number of companies have been hard-pressed to do. Assess potential risks of use in high-risk professional contexts. We identified 3 professional contexts, but medicine is another really important one. You all mentioned use in kind of engineering. That'd be another really interesting one to assess. Provide opportunities for users to provide feedback. Educate users to not take the output at face value. Focus on harm to humans when looking at risks and AI principles and focusing on the most at-risk communities. And conducting a risk assessment along different parts of the AI lifecycle, such as in data sets and model outputs. And like I said, we've pretty much wrapped up the human rights assessment. We're now in the drafting process, and we're expecting to release it in the first quarter of 2025, so keep your eyes out. And now, I'll hand it over to Jay.
Thank you. I actually have to say I'm actually quite shocked how many of you use ChatGPT. It was very interesting and illuminating for me. As Betsy mentioned, I'm Jay Aronson. I founded and direct the Center for Human Rights Science at Carnegie Mellon. Just to give you a kind of very brief sense of what we do, we're really about collaborations. We partner with people in the human rights community and people with scientific and technical knowledge to do things that are in service of human rights. We also have in the past provided technical assistance to individuals and organizations in the human rights space. Doing that a little bit less of late, but always happy to come back to that kind of thing as well. Me as a person, I've worked in a very wide variety of spaces, always addressing needs of people who are working in communities that are experiencing harm. So the earliest work I did in human rights was the use of DNA identification in post-conviction contexts. So giving people who have been potentially wrongfully convicted of a crime access to information and evidence that might demonstrate that they are innocent of that crime. That evolved into the use of DNA identification after conflict and disaster. And while I was doing that work, interestingly, a colleague contacted me about how do we know how many people die in conflict? And it was a question that I had thought a little bit about, but not much. But I'm always looking for new problems and new things to think about. And that led me to work with a variety of people on a project on counting civilian casualties in conflict. And the challenges of recording and estimating deaths in very chaotic contexts where the normal vital record systems break down. When I was doing that work, this was in 2010, 2011, 2012, a lot of the people who I was interviewing about civilian casualties were telling me that they were beginning to get lots of video coming out of conflict contexts that could potentially provide information about the number of people dying or who was dying. And they were quickly being overwhelmed by that data. We now kind of take that for granted, that people are recording horrible things that are happening to them and then posting it online or sharing it. And they were like, "You're at Carnegie Mellon. Certainly, you must know how that if there are technologies that are available that we can use to try and get through this information a little bit more quickly." And I didn't know anything about it, but Carnegie Mellon is a very collaborative place, so I went back and turns out that there were people being funded by the intelligence community to do exactly that kind of work, to extract features and relevant information from video, from large corpuses of video. And I was able to share a lot of that work with the human rights community. Now, a lot of the tools that we're developed by the defense community and intelligence community funding are now available to everyone. So it's been quite interesting to watch that happen. But once you've extracted features or once you know what's going on in a video, you still need to turn it into something that can be useful in achieving some sort of justice, whatever that might be. So I started a collaboration with a group of Ukrainian human rights lawyers and architects, actually, at C2 Research in Brooklyn, and we developed a system or a set of systems and packages for actually presenting the data that we were capturing from video and other sources, and actually reconstructing events in 3 dimensions. When I started this, it was very new. Now you can just go on New York Times or BBC or Guardian, Forensic Architecture, C2 Research. There are lots of places where you can get this information, or you can see these kinds of reconstructions. They're amazing, but it took time to develop the systems. And as I was involved in the analysis of video evidence abroad in Syria, South Africa, Ukraine, Mali, elsewhere, I was also seeing videos of police brutality and even police killings in the United States, and that got me interested in human rights violations happening right here in this country, within a few blocks of this place, down the street from where I live. And a chance question that I asked to a guy named Roger Mitchell, who was the chief medical examiner of Washington, D.C. at the time, is now the president of Howard University Hospitals, led to the work that I've been doing for the past 7 years on death in law enforcement custody in the United States. And I think what unites all of these projects, some of them are more engineering, building systems, some of them are more about gathering information and sharing it, is the use of science and technology to advance the cause of human rights and to seek justice and redress in various forms. So I just wanted to present to you some of the core values that have animated my work and have animated all the collaborations that I've done. Some of which you've heard, and maybe I wasn't here yesterday, but maybe some of it came across yesterday. But the first core value is only working with people who are either directly impacted by human rights violations or have direct access to to communities that are experiencing human rights violations. I think that's the nothing about us without us. We, as people who have access to technology and have access to knowledge, might have all kinds of ideas about what the world needs. But the reality is that what people who are impacted by human rights violations need is generally not what we in our very comfortable offices think they need. And our goal is always solidarity. We want to make the practitioners we work with more effective and efficient. We don't want to bypass them or render them unnecessary. We've heard about humility a couple of times this morning. I'm super excited about that. Only people who experience things in their lives are experts in those things. That's I think that's a kind of core value. One thing that I don't know if I need to go into this a lot here. Maybe I do, maybe I don't. But I, as a person, and all of the people I work with, I make sure they're skeptical about technology. If technology could solve social and political problems, we actually wouldn't have social and political problems. But it can't. We take a lot of time to develop trust, and we are very deliberate and cautious in the work that we do. It takes time to understand people's needs. When you're failing fast and breaking things in the context of human rights, you're often failing fast and breaking human lives, and we take that very seriously. Again, not something I need to really focus on heavily here, but one of the things that I've learned is that technology is really a double-edged sword, particularly in the human rights context. The exact same technologies and systems that can promote and protect human rights can also be used to violate human rights. The data analysis, the very tools that we were using for video analysis were developed by the intelligence community, are used every day in in military activities. So I teach a class on drones and autonomous weapons, and it's evolved into really evolved into a class about war algorithms, the use of algorithms in conflict. And we talked about Lavender in Israel-Palestine, the system that was used particularly in the early days of the conflict to identify Hamas targets. So we would potentially be using similar technologies to identify human rights violations, but they're also the ones that enable those kinds of things. So it's impossible in this context to have benefits without harms, positives without negatives. The very features that make technologies useful in human rights work are the very features that make them dangerous. And you're a bunch of engineers. I hope that you know that technology isn't neutral and that design reflects particular norms and values. So technology doesn't automatically promote and protect human rights. You have to be very active and very intentional in making decisions that make those technologies or enable those technologies to promote human rights. Again, I think that we've heard some of this before, so I'll move through it quickly. I think human rights and human rights law provides a really important source of norms and values. I could get into the technical side of things, but as our previous speaker mentioned, I wasn't sure what your level of legal knowledge would be, so I tried to put this all in as plain English as I possibly could have. I think the most important norm or practice is to always focus on the most vulnerable and least powerful, to engage in conversation with them, to learn from them, not to provide them with solutions that you think they need. All the work that I do and will do is really explicitly created to promote access to accountability and justice mechanisms, however those people are, or however those particular mechanisms or institutions are constituted in whatever context I'm working. We talked about participation. That's core, not just participation in sort of having a conversation about something that's already been decided, but about the people who are impacted actually being at the table when decisions are being made. I like to joke that sometimes at my institution and probably others, decisions are made and then discussions are had, and that's not at all what I'm talking about here. I think we need to recognize that power and privilege are built into technological systems. If we want technology to have a positive impact, it doesn't just happen magically. We actually have to engineer that into the systems. And a recognition that technology impacts all aspects of our lives and our rights. So just one little thought that from the LLM conversation, and maybe I'll end here, that as we're using these LLMs in our work, we're also creating environmental hazards for particular people in particular places. The benefits and the harms are not always equally distributed around the world, and we need to be very conscious of that. So I will stop there so that we have time for conversation, and I will pass the clicker on to Julie if you have slides.
Yeah.
Thank you.
Good morning. Very glad to be here. My name is Julie Owono. I am the executive director of a nonprofit, international nonprofits with headquarters in France, Paris, called Internet Sans Frontières, or Internet Without Borders. And if you allow me, I would like to add a little edit to my, tag name here. Because I do not represent Meta. I work for an external body to Meta, which is called the Oversight Board for Meta. But I do not work for Meta. And the distinction is extremely important for me, and you will understand why. Because I will present to you some people call it experiment. Some others ambitiously, including the founder of then Facebook, now Meta, Mark Zuckerberg, famously called it the Supreme Court of Facebook. I said ambitiously because, of course, with all the humility possible, there is no way we can come close to the very inspirational and unique work of the U.S. Supreme Court. But all this to... Well, yes, well, okay, yes. That's but it remains that this body, probably as a French journalist from Le Monde called it famously in 2020 when the board was launched, he called it an ovni juridique, so a legal UFO. So we don't really know what that is. There's ambition, but yeah, we'll see. So I think this legal UFO is an extremely interesting example of how we can, at the intersection of engineering and human rights, reconcile this, the research for justice, protection of human rights, while at the same time, encouraging or supporting, some people will call it innovation, but generally, yes, technology development and to some extent progress. So, yes. So the Oversight Board was established in 2020. Actually, probably slightly before that. I think you will all remember, in 2018, we all remember the founder of Facebook was at the hearing, here, in DC, to explain to elected officials from the United States, or elected representatives from the United States, what happened, what was the role of his technology, allegedly in the 2016 U.S. presidential elections. And it was virtually, I think, the first time that a powerful CEO of a technology company acknowledged that sometimes, yes, our innovation can cause disruptions, to speak neutrally at this stage. And after this hearing, I personally remember very well reading a Facebook post by the same Mark Zuckerberg, saying that he as a CEO should not be in a position to make consequential decisions about what speech or what expression would be allowed on the platforms developed by Facebook at the time, so Facebook, Instagram, mainly. And he worked with several experts. If some of you have read it or have the time to read it later on, I strongly encourage you to read a New Yorker article that was published in, if my memory is correct, February 2021. It was a 2 or 3 years investigation by a law professor called Kate Klonick, who is one of the best analysts of platform governance, which is the field, the emerging field of studying the impact and the governance of technology platforms. And in this article, we learn that one famous law professor at Harvard University, sorry, I have a blank here, but a famous constitutional law professor at Harvard University, who happened to be one of the former classmates of Sheryl Sandberg, who was then the number 2 or number 3 of the company, had this idea while cycling, riding his bike, had this idea of creating this Supreme Court of Facebook. And so Mark Zuckerberg wrote about it on his Facebook page. And there were a series of consultations that happened. My organization participated in many of those, actually mainly 2. One in Nairobi in Kenya, which gathered, I would say, 30, 50 stakeholders from the sub-region, from sub-Saharan Africa. And we also participated in in one meeting in Berlin with the same aim of gathering stakeholders. Gatherings convened by Meta, Facebook at the time, to kind of design to give a little bit of flesh, right, to this, what could be this Supreme Court of Facebook. And fast forward 2020, this Supreme Court was kind of born. I had the extremely huge privilege. I still remember when they called me and said, "Oh, you will join, Helle Thorning-Schmidt, who's the first female prime minister of Denmark. You will join Professor Michael McConnell, who is the director of the Constitutional Law Center at the Hoover Institution." I felt very, very weird, extremely honored, but extremely weird to be in this position. But we were launched in May 2020. As you can see, it's a group of diverse individuals who are all experts in their respective fields. We have journalists, former editor of The Guardian, Alan Rusbridger, probably you will recognize him in the middle. We have a former Director General of the Minister of Justice of Israel, Amy Palmore, who's right next to me on the picture. You have Tawakkol Karman, top left, I think, yes. Top left, Nobel Peace Prize winner 2011 from Yemen. Geographically, expertise, diversity is really at the center of our DNA. And why this expertise is extremely important, it's because we are talking about technology platforms, social media platforms that are not only used in the United States, but that are heavily used by 3 billion people, probably more now, daily, around the world. And so it requires, and it operates on a space that is borderless, hence the name of our NGO. I always say that if ever we put borders on the internet, we would run out of business. So virtually available everywhere to everyone. How do you even begin to think about in respecting human rights in this uncharted territory? And so we were launched with the idea that we would help Meta now enforce its community standards, so the rules that apply to its platforms. For instance, you're not allowed to post hate speech on Facebook. You're not allowed to support terrorist organizations. You're not allowed to, promote violence against children, child abuse. You're not allowed to do certain things. And so we make binding, principled decisions on content that has either been taken down by Facebook, so deleted by Facebook, Meta, or that has been left up on Meta's platforms. And the platforms that we're talking about are specifically Threads, Facebook, and Instagram. To do so, we decided to focus on a certain number of strategic priorities that we chose based on, the most harm, the potential harm against human rights in each of these priorities. If you look at the first one, for instance, elections in civic space, we've just passed, we're almost winding down a year of tsunami of elections. I'm sure you've heard that expression. What does free expression mean when there is an election, but there is also disinformation, there is also, where should a platform like Facebook be in terms of allowing human rights to flourish while also safeguarding other very important human rights? Another strategic priority, which is right next to elections in civic space, is crisis and conflict. We live in a world of extreme instability. Since we've started the board, so in 2020, we've seen already at least, I've counted, 4 regional and important conflicts. Ukraine and Russia being, of course, the one that comes up to mind, and absolutely the one in the Middle East right now, in the Gaza Strip. Gender is another strategic priority that we identified. There are reports about how the inequalities that we see offline, so in our very real material, physical world, are the same inequalities that are translated in the digital world, and therefore affecting mostly marginalized or minority, individuals, and in this case, female, women. I won't go through all of them, but I think one is particularly of interest. All of them actually are, but one that I wanted to mention, which is not yet on this slide, I realize it now, is the question of children. How to protect children's rights on a platform like Instagram. How to protect, how to enforce, for instance, the global, the international forbiddance of child marriage, right? Internationally, there's an agreement, there's a convention that says that children should not be, married before being of an age where they can consent freely. How do you enforce, of course, the question of child abuse? How do you enforce the question of the mental health of children, which is also a fundamental right of children? All these questions are around the strategic priorities, guide our work. And our work, as I was saying, is to work on cases. So we accept cases. So we will look at our strategic priorities and we will try to identify in our queue of appeals cases where we can touch upon the strategic priorities that I mentioned. Because indeed, we receive appeals from users. So if you're a Facebook, Instagram thread user, you can appeal to the board to remove or restore content, your personal content or someone else's content. We also receive cases directly from the company when the company faces particular difficulty enforcing one of its rules in a manner that respects human rights. And I should probably rewind a little bit and say that when Meta started reflecting on this human rights and Supreme Court sort of experiment, Meta at the same time committed to respect the UN guiding principles that you helpfully and rightly reminded us of, Betsy, which strongly encourage companies to mitigate adverse effects to human rights. So Meta does refer cases to us, and we can also make recommendations. So it's very important to specify that the decisions that we make on cases are binding. So whatever we tell Meta, Meta must do it. And sometimes it's very contentious. I remember a specific case which involved the Prime Minister of Cambodia. I think I can talk about this publicly. The Prime Minister of Cambodia, who was accused through an appeal that we received, I think directly from Meta, was accused of using the platform to incite violence against other Cambodians from the opposition party in a time of election. Well, our very contentious decision, led us to tell Facebook, to mandate to Facebook that his account should be suspended for, I think, 30 days in application of the rules set by the platform. Because the platform says that if you violate the same rule X amount of time, you can be subject to suspension of your access to the social media. And so we mandated that the sanction be applied. And I am unfortunately very sad to announce that all of us, the 22 people that you saw on the picture earlier, we're all currently banned from transiting through Cambodia. And if we do so, we could be arrested or I don't know what else, but yes. So in addition to the binding aspect of our case decisions, we can also make recommendations. And these are, as their name will suggest, non-binding, which means Meta can decide to enforce them or accept them rather, or not. But the interesting part of the recommendation is that although non-binding, nevertheless, Meta must respond publicly to those recommendations. The response can be, yes, we will implement this. We think it's a great recommendation. Or, no, we will not implement this, but we will not implement this because. and the because is the most interesting part, I think, of this whole public conversation around enforcing rules on a social media platform in a manner that respects human rights, because it tells you a lot about the limitations, the internal limitations sometimes that the company will face in applying the recommendations. Some of these limitations can be technical. Some of these limitations can sometimes also be related to, concerns that there is increasingly regulation in XYZ part of the world that contradicts the potential recommendation that we're making, and therefore the company would like to take a little bit of time to think about this. So the recommendations part are extremely interesting because they are a very powerful tool of transparency. Actually, if you go to a platform, a website, I think it's fb.transparency.com, you will see the whole list of recommendations made by the board since 2020, and the whole list of those recommendations which have been fully implemented, partially implemented, or rejected by the company. To give you an example, a deep dive into an example, I would like to share one about one of our very first decision, which was related to breast cancer awareness raising. It was a case about a campaign for breast cancer awareness, a month, posted by an organization located in Brazil. And obviously, it's breast cancer, so there was an image of a female breast. As some of you might know, there is a policy against adult nudity on Meta's platforms, and specifically against, female breast, with some exceptions, which include the exceptions include breastfeeding, for instance, or awareness raising for diseases such as breast cancer. But in this case, we identified that the content had been automatically taken down, and wrongly. It was a content that was falling into the carve-out that was provided by the community standard. And so we recommended that Meta, enhances the human review of such content that involves content that could represent awareness raising on breast cancer, but that could be mistaken by an automated moderation agent, that could be mistaken for a content that is not allowed. And as you can read, the recommendation forced Meta to kind of work technically on this. They accepted this recommendation, and it led them to test and deploy a new health content classifier to help the company identify automatically image-based content about breast cancer, so content that could be eligible for the carve-out provided by the policy. And in 1 month, we could see, or at least the company itself reported to the board through our implementation committee meetings with the company, because we do have a committee that's in charge of following through on our recommendations. And so the company reported that it saw an additional 1,000 pieces of content about breast cancer being more visible or not taken down on the platform and now sent for human review. These type of systemic changes through the lens of one specific case is exactly the theory of change of the board. We have received so far 2 million plus cases. So there is no way that the 22 of us can meaningfully look at each of these appeals. And I almost want to say provocatively, the role of the board, the interesting part of the role of the board is not necessarily in being a super content moderator who will review even more content than the moderators that the company hires or outsources at the level of the social media platform directly. No, instead, it's in the principal decisions that we make, the ability that we have to investigate. We have time to do that. Our normal standard case timeline is 90 days from the time we accept the appeal to the time it's published and sent to Meta. But we can also work urgently. We've done so very recently. I was talking about that conflict in decisions involving the hostage situation at the very early days of the war in Gaza last year. We can take cases and make decision as early as 1 week up to 30 days. So we try to be as flexible as possible without compromising on our ability to provide principled decision informed by international human rights standards. What are these? What are these standards that we're looking at? Simply the International Covenant on Political and Civil Rights, which says freedom of expression is a paramount value of democratic societies. In order for a state or any other powerful agent to trample with that, there must be a very clear rule, so the legality principle. The trampling with the freedom of expression should be proportionate to the objective that we have in sight, and should be necessary. So there should be no other way than to censor, basically. And so this is our theory of change. By making those principled decisions, we believe and we have seen that systemic changes can happen on the platform and impact way beyond the individual case that we worked on. So of course, like I was saying, 2 million cases since we started. We can't look at all of them, but we have criteria to choose some of them. We actually have a case selection committee, which is tasked with selecting those cases. Yes. Yes, sorry, yes. All this to say, here are the criteria, mostly contentious issues that require clarity, issues that raise human rights concern, and potentially a case that could have significance beyond the individual case discussed. I'll end there to say that we do this work, of course, by convening and deliberating, and much of our deliberation are based on public comments that we accept for every individual case that we work on, and even every recommendations that we want to make to the platform. So that's also another way to engage with us. I'll stop there and look forward to the conversation. Thank you.
Okay, Jose, over to you.
This is it.
Are you able to control it yourself? Oh, you're muted. We cannot hear you.
Is the AV person? I don't know if they need to.
Sorry, can you hear me now?
Yeah.
Yes.
There we go.
Okay, perfect. Apologies for that. So I'll try to keep it brief, given that I think we're already running out of time, and it'd be good to have a little bit of a discussion. So I'm going to be taking a slightly different angle, looking into how science can support safety as a human right. Safety is an interesting aspect of human rights because it's one that doesn't seem to appear explicitly anywhere. If you look at, for example, the Sustainable Development Goals, you will find that in all 17, the word safety is not mentioned. Nevertheless, it's something that we assume that we as a society provide, to everybody. Now, if we look more in detail, we will see that this appears in many documents, and including the 1948 Declaration of the United Nations, and it's really important to understand that it covers pretty much all citizens, individuals, civil social groups, and it addresses the right that we have to have safer products, safer working and living conditions, and a safer environment in which we live. And governments are responsible to try to provide, that level of safety. Now, the real question here is what is the role of science in supporting safety as a human right? And this is a space in which I have been working for a number of years, and many times I think that we tend to think of safety as a common sense aspect of our everyday lives. But most of the times, it's actually a very complex technical problem that requires high levels of competency from all those that are involved. So individuals who actually understand how to deliver safety will have some very, very specific technical knowledge. In my case, I'm a fire safety engineer, and therefore my space of work tends to be problems associated into how to deliver fire-safe environments, fire-safe products, and how to address issues like wildland fires, for example. And all these events, if they are not treated appropriately, will have an extraordinarily negative impact on people. And the impact that it can have on people can be very different and many times somehow unexpected, and we need to look at it in a very careful manner. And many times, we face an element of responsibility that is very important because we become witnesses to the fact that science is being misused and technical knowledge is being treated in a manner that is to the detriment of people's safety. So what is the role that we are supposed to take when we become witnesses to these forms of practice? And we actually have the knowledge and competency to understand that people are misusing science and technical knowledge. And many times it could be completely unaware that they are doing this, but many times it's actually done in a very proactive way. So I'm going to try to explain this by talking briefly about a few examples of cases in which I have been involved. Many times these cases involve sectors of the population who actually don't have the means to be able to defend themselves or to demonstrate the fact that technical knowledge is being improperly used. So a lot of these situations tend to also address issues of inequity, where those who have the means have the capacity to change the outcome to the detriment of those who don't. So let me give you a few examples so I can illustrate a little bit what I'm talking about. So the first one is a case in Chile, in South America, and it relates to the management of prisons. So inmates, like any other human being, they have human rights. And as part of those human rights, they have the right, to be kept in a space that is safe. Now, the reality is that in most countries, prisons are overcrowded, mismanaged. They carry numerous hazards, and this was a case in which a prison that was completely overcrowded, where what prisoners were allowed to bring resulted in a multiplicity of hazards, landed us in a situation in which there was a very big fire. And the very big fire cost the lives of a number of people. And the debate that became a legal debate was who is responsible for this. Now, the government accused the custodians of the prison of not intervening fast enough and to be able to save the individuals who were locked in their cells. Now, the reality is that what this highlighted was the fact that it was the mismanagement of the prison that created a condition that completely disabled the custodians from being able, to rescue the prisoners, and the discussion turned around very fundamental scientific principles of fire growth and how you can actually show that given certain materials that you're using within these prisons, you would expect a fire that actually cannot be managed. In a similar way, if you look at the case in Paraguay, then the problem is an issue of obsolete regulatory practices that allow for an event to happen that cost the lives of a number of different people in a supermarket where certain combustible materials were allowed to be placed too close to heated elements that resulted in the deaths of a number of individuals. Now, obviously, again, then you have the owners and managers of the supermarket who turn their faces against an, an individual who in this case is the manager of the store and accuse the individual of not enabling the egress of people out of the supermarket, and as a result costing them their lives. Now, if you actually look technically to what is happening in that space, you will realize very rapidly that the building manager could have done nothing to try to accelerate the egress of people to the point where it would have changed the outcome. Now, the case in Afghanistan is a case where an aid organization handed over blankets to hospitals without recognizing that the blankets that were providing did not meet appropriate standards of flammability. So the unqualified users, which is the people who were being attended in the hospital, used these blankets to cover themselves from the cold, but at the same time used heating elements, electrical heating elements that resulted in the ignition of these blankets, and in many cases people that were very vulnerable and they didn't have the capacity to be able to remove the blankets ended up having severe injuries and in many cases, dying. Now, this raises a very complex question about aid organizations and how aid organizations many times are not careful enough in doing their due diligence, on the aid that they provide, to users that are not in a position to be able to understand whether they're being given something that is safe or it is not. The case in South Africa is a case of irresponsible corporate practices, where you have a factory that fundamentally decides to alter the interior of the factory to construct a restaurant, and combustible insulation that is used in the ceiling of the factory ends up igniting because of just standard kitchen practices. The result is that this poorly designed restaurant ends up trapping all the people who were dining at the restaurant, resulting in numerous deaths. Now, if you think of that case, then this is a case of an imbalance of power, where effectively the company blames the cook in the kitchen of having started the fire without recognizing that the inappropriate placement of that mezzanine in proximity to this combustible insulation was actually at the origin of the event. And nevertheless, they have the means, the power, to try to be able to present, to the legal system, a case that in principle has the potential to absolve them. Nevertheless, when you look at the side of the cook or the sides of all the bereaved who lost their family, the relatives in this fire, then somebody needs to be able to bring appropriate technical knowledge and science to try to establish that this type of practices of constructing these things without taking proper technical steps can result in a major problem. Now, I can keep going one after the other one, but I think I just want to raise finally the last two. In the case of Mexico, it is a case where government uses technical knowledge that is completely inappropriate to sell a story to a group of bereaved families who had lost their children, 46 of them. And the inappropriate use of technical knowledge is so blatant that you can almost perceive that there is a motive behind it. Now, the interesting thing about this is the implications, because when you work as a technical advisor in any of these cases, you really have to maintain that technical advisory role. But it's very, very difficult when you're facing injustice and you're facing situations like this, to actually abstract yourself, from the social, political, emotional side and try to retain your role as a technical advisor. This is a case that was very, very, very difficult to be able not to cross that line. And the final one is one that I just finished working, which is the Grenfell Tower inquiry. And again, this is a case where the challenge is to show government that they've created a set of regulations that actually disadvantage the vulnerable. They promote social inequity because of the way the regulatory framework is established. And then you use your technical knowledge to try to help people understand that. So I hope I have illustrated with these examples, a different angle, which is the angle of looking at safety from a technical perspective and understanding, how you use that technical knowledge in support of people's human rights. Thank you.
Thank you, Jose. We're already over a little bit, so we have 10 minutes for questions. Let's start with folks in the audience here. Let's take 2 at a time.
Thank you to the panelists for this wonderful discussion. My name is David Chacon Hurtado. I'm an assistant professor at the University of Connecticut. And this is a question for Jay and Betsy, but I think it's also very relevant to the previous panel on participatory decision making. And this is related to the fact that one characteristic, and usually what I call the beauty of human rights frameworks applied to engineering, is that it requires us to focus on the most vulnerable groups, right? And this is looking, for example, at minority rights or minority groups. But this comes with a great responsibility that is that we have to ensure that this process of engagement do not generate or do not pose any additional risk to these already vulnerable groups. And in the age of technological developments, new communication technology, AI, how is that engineers or technology developers can ensure that this does not happen? Thank you.
Okay. Thank you.
Is this on? Okay. I'm from Boston University, and my question, I guess, is kind of piggybacking off of that one a little. If we can't ensure that AI doesn't cause harm, and it seems like more and more it's kind of showing that it will, should we not stop using it altogether? I'm kind of reminded of leaded gasoline from the 1920s. It took us 70 years to ban that, despite the, considerable public harm that it caused. Are we kind of not at a watershed moment now of maybe we shouldn't be using this altogether?
Okay, thank you. Do you want to go first? I'm happy to start.
Oh, if you're happy to start, go ahead. Yeah.
Okay. On the last question, I mean, the cat's out of the box, right? Like, it's already in use. There's no way to put it back in the box. And so I think now that's why we're at the point where we have to assess, like, what some people are focused on the big risks. What does this mean in terms of, like, if it's able to overtake, like, human minds and kind of focus on, like, really long term. But I think we need to focus on the here and now and solving it in the here and now with a multidisciplinary group. And so, that's why I mentioned, at least for kind of use in kind of different professions, involving multiple players and kind of taking up their role to solve the rest. I'm not going to pontificate on whether it should have been created in the first place, but it is, and we're using it. And, I do think there are a number of risks at play, but we were able to identify a number of advantages as well. And, there is a human right to scientific advancement and the use of science. And so it is kind of also advantaging humans in some respects as well. In terms of the involvement of vulnerable groups in kind of the process, it's one of the reasons we engaged people around the globe, because we saw that, the way in which, folks in North America and Europe use LLMs is very different than in other parts of the world. And, particularly in communities that are more disadvantaged, either from an economic perspective, And so we wanted to include their voices to learn how they used it, and also get their suggestions for like what risks they saw and how they could see those being countered. So I do think it's very important to involve kind of the most at-risk communities in kind of the work you're doing and kind of include them in a participatory way. So thank you both for those questions. Okay.
Yeah, I'll be really brief. On the one hand, I want to say yes, let's stop using AI. On the other hand, I mean, I think that's pretty amazing that you can get real-time transcription of spoken text in many different accents with pretty high accuracy. So I think we have to be thoughtful about that. As far as the participation question, I think that the nothing about us without us, or no decisions about us without us, is really the way that I've always thought about it without actually using that language. So now I have a new way of using it, of explaining that. But when I'm doing any of the work that I'm doing, looking for groups, I always look for groups that have been around a long time and haven't formed explicitly, particularly around the issue that or the technology that I'm interested in. I think that reduces the possibility of grifting and of people who aren't who don't necessarily actually have connections into the community. But it's really hard. There's no shortcut. There's no shortcut to doing a lot of due diligence, asking a lot of people in the community, hey, do you know this partner? Do you know this organization? Making mistakes and knowing when it's time to just say, I'm not going to go any further with this. So yeah, I could go on and on, but I think that's a shortish answer. So thank you.
I wanted to share a very brief example of the dangers of a general ban on AI. So I came across this example from Venezuela, where there is a very serious political crisis, post-election crisis. And we have seen examples of civil society organizations who, by the way, are repressed heavily. Some of them disappearing, many being imprisoned for speaking up against what the alleged rigging of election, and using AI to conceal their identity while at the same time allowing their message to widely circulate on the internet. So I would encourage, and I completely agree on the necessity of including the communities within the conversations we're having about human rights and technology.
Mm-hmm. Jose?
I'm fine. I don't really have anything else to comment.
Okay. Do we have time for one question from the internet?
Okay. Patricia Evers asked, if international law is binding on countries rather than companies, how can we hold private organizations to account when their actions are not in line with international human rights norms and standards?
So I will say the UN guiding principles on business and human rights are voluntary principles. So they're actually not enforceable. Companies have to voluntarily say that they will abide by the principles, and most of the big companies these days do voluntarily accept them. So the pressure there is more from like a public perception standpoint and a shareholder standpoint than from kind of a legally enforcement standpoint. And I realize we're over time, so I'm going to wrap it up there. Thank you, everyone, for joining us for this panel today, and we look forward to seeing you all after lunch.
Thanks very much, Betsy. To you and your panel, I interestingly, there was a question that came up in my mind when you first started, and that was, we collect terabytes of data on issues of human rights. And in my mind, I'm still trying to wrestle with the fact that it seems we do nothing with the data that we collect over time. So maybe my misperception is wrong, but thanks very much. We're going to take a break for lunch, and please try to be back in your seats in order to start at 1 o'clock, 1300. Thank you.